coercion can be mental as well as physical. If neglect statutes conflict with the Fourth Amendment, they must be deemed invalid. The state registers no gain towards its declared goals when it separates children from the custody of fit parents. A showing of harm to the child as a prerequisite for coercive state intervention, statutes incorporating drug use focus on parental behavior and thus subvert themselves. By preserving references to parental misconduct as factors to consider in neglect determinations, statutory law undermines the express requirement that harm to the child be a sine qua non of intervention. The result of this is that such cases often begin to resemble criminal proceedings against errant parents. The assumption that drug use constitutes neglect inappropriately shifts the focus from the welfare of the child to the behavior of the parent. The parenting, not the supposed quality of the individual who is the parent, should be at issue. A trial court cannot terminate a parent's rights absent this finding of unfitness. Parental deficiencies alone do not render a parent currently unfit. The proper inquiry is whether the existing parental deficiencies, or other conditions, prevent the parent from providing for the child's basic health, welfare, and safety. The court explained absent some tangible evidence of abuse or neglect, the courts do not authorize fishing expeditions into citizens' houses. Mere parroting of the phrase best interest of the child without supporting facts and a legal basis is insufficient to support a court order based on reasonableness or any other ground. An officer who obtains a warrant through materially false statements which result in an unconstitutional seizure may be held liable personally for his actions under Section 1983. Defendants could not lawfully seize child without a warrant or the existence of probable cause to believe child was in imminent danger of harm. Where police were not informed of any abuse of the child prior to arriving at caretaker's home and found no evidence of abuse while there, seizure of the child was not objectively reasonable and violated the clearly established Fourth Amendment rights of the child. Miller recognized the fundamental liberty interests by parents in the care, custody, and management of their children, an interest which must be balanced against the state's interest in protecting children suspected of being abused. To act under color of state law means the social workers acted beyond the bounds of their lawful authority, but in such a manner that the unlawful acts were done while the official was purporting or pretending to act in the performance of their official duties. In other words, the unlawful acts must consist of an abuse or misuse of power which is possessed by the official only because they are an official. The social workers committed a misuse of power, possessed by virtue of state law and made possible only because the wrongdoer is clothed with the authority of state law, is action taken under color of state law. An unreasonable belief of imminent harm to a child will render a seizure unreasonable. Right to procedural due process violated, the state denied the plaintiff the fundamental right to a fair procedure before having their child removed by the intentional use of fraudulent evidence during the procedure. The forced separation of parent from child, even for a short time, in this case 18 hours, represents a serious infringement upon the rights of both. Loss of First Amendment freedoms, for even minimal periods of time, unquestionably constitutes irreparable injury. Though First Amendment rights are not absolute, they may be curtailed only by interests of vital importance, the burden of proving which rests on their government. Parents and child had a clearly established liberty interest in associating together. This right was violated where the defendants allegedly had no indication of any physical neglect of the child, no indication of any immediate threat to his welfare, and no indication of any criminal activity by his mother, where they had only third-hand hearsay that the child's mother had gotten drunk and failed to pick up the child from his babysitter, and where defendants refused to return the child, had not investigated to determine whether it was necessary to remove the child in the first place, and had not investigated the possibility of returning the child to his mother, grandmother, or anyone designated by the mother. In reversing the conviction of a teacher who violated the law, the court held that the Due Process Clause protected the power of parents to control the education of their own children. This right to the preservation of family integrity encompasses the reciprocal rights of both parent and children. In 1923, the Supreme Court held that there was a constitutionally protected right of parents to establish a home and bring up children. Thus, the qualified immunity analysis has two prongs: 1. Whether the official violated the plaintiff's constitutional rights, and 2. Whether the right violated was clearly established at the time of the official's conduct. For a right to be clearly established, the contours of the right must be sufficiently clear that a reasonable official would understand that what he is doing violates that right. That is not to say that an official action is protected by qualified immunity unless the very action in question has previously been held unlawful, but it is to say that in light of pre-existing law the unlawfulness must be apparent. The Supreme Court reaffirmed that choices about family life, and the rights of parents to raise their children, are rights of basic importance in our society. These rights, the court wrote, are to be protected from the state's unwarranted usurpation, disregard, or disrespect. Plaintiffs' clearly established right to meaningful access to the courts would be violated by suppression of evidence and failure to report evidence. Child removals are seizures under the Fourth Amendment. Seizure is unconstitutional without court order or exigent circumstances. Court order obtained based on knowingly false information violates Fourth Amendment. A child has a constitutionally protected interest in the companionship and society of his or her parent. The social workers and court officials consisted of two or more persons who conspired to injure, oppress, threaten, and intimidate the mother and her minor child, in the free exercise or enjoyment of any right or privilege secured to the mother by the Constitution or the laws of the United States, or because of his/her having exercised the same. It further makes it unlawful for two or more persons to go in disguise on the highway or on the premises of another with the intent to prevent or hinder her free exercise or enjoyment of any right so secured. Absent extraordinary circumstances, a parent has a liberty interest in familial association and privacy that cannot be violated without adequate pre-deprivation procedures. The court held that where abusive government action by a member of the executive branch is alleged, only the most egregious official conduct can be said to be arbitrary in the constitutional sense. State employee who withhold a child from their family may infringe on the family's liberty of familial association. Social workers could not deliberately remove children from their parents and place them with foster caregivers when the officials reasonably should have known such an action would cause harm to the child's mental or physical health. Under this standard, executive action will not expose the official to liability unless it is so ill-conceived or malicious that it shocks the conscience. ID. The court emphasized that Croft was simply an application of the traditional substantive due process shocks the conscience standard, stating that only in rare circumstances can allegations of neglect be so severe or credible that an investigation into the allegations is not required for removal. A defendant in a civil rights case is not entitled to any immunity if he or she gave false information either in support of an application for a search warrant or in presenting evidence to a prosecutor on which the prosecutor based his or her charge against the plaintiff. The court held that the CPS case worker, acting on an anonymous tip with multiple layers of hearsay, without any corroborating evidence, and without any evidence that convinced her one way or another that there was any sexual abuse involved, had insufficient justification for such a drastic infringement on parental and children's rights, familial integrity, and so was an arbitrary abuse of government power. Fourth Amendment protection against unreasonable searches and seizures extends beyond criminal investigations and includes conduct by social workers in the context of a child neglect/abuse investigation. Court held that an anonymous tip standing alone never amounts to probable cause. Defendant should have investigated further prior to ordering seizure of children based on information he had overheard. The mere possibility of danger does not constitute an emergency or exigent circumstances that would justify a forced warrantless entry and a warrantless seizure of a child. In context of a seizure of a child by the state during an abuse investigation, a court order is the equivalent of a warrant. Child protection workers are subject to the 4th and 14th Amendment in the context of an investigation of alleged abuse or neglect, as are all government officials. The court ruled despite the defendant's, child protection worker, exaggerated view of their powers, the 4th Amendment applies to them, as it does to all other officers and agents of the state whose request to enter, however benign or well-intentioned, are met by a closed door. The Fourth Amendment's prohibition on unreasonable searches and seizures applies whenever an investigator, be it a police officer, a DCFS employee, or any other agent of the state, responds to an alleged instance of child abuse, neglect, or dependency. The Constitution also protects the individual interest in avoiding disclosure of personal matters. Federal courts, and state courts, under Griswold can protect, under the life, liberty, and pursuit of happiness phrase of the Declaration of Independence, the right of a man to enjoy the mutual care, company, love, and affection of his children, and this cannot be taken away from him without due process of law. There is a family right to privacy, which the state cannot invade, or it becomes actionable for civil rights damages. The court focused on whether the information available to the defendants at the time would have created an objectively reasonable suspicion of abuse justifying the degree of inference with the parents' rights as the child's parents. In the absence of such reasonable grounds, the governmental intrusions of this nature are arbitrary abuses of power. Due process requires the trial court to explicitly or implicitly find by clear, cogent, and convincing evidence that the parent is currently unfit. A due process violation occurs when a state-required breakup of a natural family is founded solely on a best interests analysis that is not supported by the requisite proof of parental unfitness. The Supreme Court ruled that testing without maternal consent for the purposes of criminal investigation violated the mother's Fourth Amendment rights. If a police officer who sought an arrest warrant and presented information to the magistrate did not have an objectively reasonable basis for believing there was probable cause to support the warrant, the officer would not be entitled to qualified immunity. Even if a magistrate made a determination of probable cause an incorrect determination and issued the arrest warrant to allow police to seize the plaintiff, the magistrate's action would not offer qualified immunity to a police officer if there was no objectively reasonable basis for the officer's warrant application. A plaintiff alleging a 1983 claim based on an unreasonable search in violation of the Fourth Amendment has the burden of proving at trial that an asserted exception to the warrant requirement did not apply. Placing burden on plaintiff to establish absence of imminent danger in claim of interference with parent-child relationship. Reaffirming that plaintiff in 1983 action carries the ultimate burden of establishing each element of his or her claim, including lack of consent to search. Placing burden on defendant to show existence of exigent circumstance at summary judgment stage. Determining the reasonableness of any search involves a twofold inquiry. First, one must consider whether the action was justified at its inception. Second, one must determine whether the search as actually conducted was reasonably related in scope to the circumstances which justified the interference in the first place. The Second Circuit held the right of the family to remain together without the coercive interference of the awesome power of the state. Encompasses the reciprocal rights of both parent and child. The court explained that children have the constitutional right to avoid dislocation from the emotional attachments that derive from the intimacy of daily association with the parent. In light of this extensive precedent, it cannot now be doubted that the Due Process Clause of the 14th Amendment protects the fundamental right of parents to make decisions concerning the care, custody, and control of their children. With respect to the Fourth Amendment, the Supreme Court has defined a seizure as a governmental termination of freedom of movement through means intentionally applied. Specific intent to violate a person's rights is not a prerequisite to liability under 1983. The filing of a grievance/complaint, whether it be verbal or written, formal or informal, is protected conduct. Threats to sue and/or pursue criminal charges fall within the purview of the constitutionally protected right to file grievances. A plaintiff may bring a Section 1983 claim alleging that public officials, acting in their official capacity, took action with the intent to retaliate against, obstruct, or chill the plaintiff's First Amendment rights. To bring a First Amendment retaliation claim, the plaintiff must allege that 1. It engaged in constitutionally protected activity, 2. The defendant's actions would chill a person of ordinary firmness from continuing to engage in the protected activity, and 3. The protected activity was a substantial or motivating factor in the defendant's conduct, i.e., that there was a nexus between the defendant's actions and an intent to chill speech. Further, to prevail on such a claim, a plaintiff need only show that the defendant intended to interfere with the plaintiff's First Amendment rights and that it suffered some injury as a result. The plaintiff is not required to demonstrate that its speech was actually suppressed or inhibited. The court held that Wisconsin's compulsory education law violated an Amish father's rights to take his 15-year-old children out of school to complete their education in Amish ways at home. The court declared unconstitutional a New York statute that authorized termination of parental rights based on a preponderance of the evidence. Santosky is the first Supreme Court case to hold that even after parents are found unfit in a contested court proceeding, they retain constitutionally protected parental rights. Thus, to demonstrate a First Amendment violation, a citizen plaintiff must provide evidence showing that by his actions the defendant deterred or chilled the plaintiff's political speech and such deterrence was a substantial or motivating factor in the defendant's conduct. Declaring for the first time that part of a woman's constitutional right to privacy, including the fundamental right whether or not to beget a child, includes the choice to terminate an unwanted pregnancy, at least in the early stages of the pregnancy. In Roe, the court restricted state power to forbid abortions, holding that a woman's decision whether to bear a child is within the sphere of privacy founded in the 14th Amendment's concept of personal liberty. Under the First Amendment to the United States Constitution, a citizen has the right to be free from governmental action taken to retaliate against the citizen's exercise of First Amendment rights or to deter the citizen from exercising those rights in the future. The United States Supreme Court held that a plaintiff cannot recover compensatory damages for unspecified injury or ask the jury to award damages based on a subjective intrinsic value of the particular constitutional right allegedly violated. The plaintiff must prove actual injury in order to justify compensatory damages. The court has held that with regard to municipal defendants, the plaintiff must demonstrate a direct causal link between the municipal action and the deprivation of federal rights, such that the municipal action was the moving force that caused the deprivation. Magistrate made a determination of probable cause and issued a search warrant, but the search warrant was defective on its face and the officer who sought the warrant was not entitled to qualified immunity. Second, because Jones is pro se, we must consider as evidence in his opposition to summary judgment all of Jones's contentions offered in motions and pleadings, where such contentions are based on personal knowledge and set forth facts that would be admissible in evidence, and where Jones attested under penalty of perjury that the contents of the motions or pleadings are true and correct. Pleading counts as verified if the drafter states under penalty of perjury that the contents are true and correct. A parent's interest in custody of their children is a liberty interest which has received considerable constitutional protection. A parent who is deprived of custody of his or her child, even though temporarily, suffers thereby grievous loss and such loss deserves extensive due process protection. A finding of dependency requires proof of present parental deficiencies. A parent's right to the custody of his or her children is an element of liberty guaranteed by the Fifth Amendment and the 14th Amendment of the United States Constitution. A municipality, county, violates the Constitution when it has an unconstitutional custom or policy. A custom or policy can take one of three forms: 1. An express policy that, when enforced, causes a constitutional deprivation; 2. A widespread practice that, although not authorized by written law or express municipal policy, is so permanent and well settled as to constitute a custom or usage with the force of law; or 3. An allegation that the constitutional injury was caused by a person with final policy-making authority. In order to state a claim under Section 1983, a plaintiff must allege that the defendants deprived him of a right secured by the Constitution or laws of the United States, and that the defendants acted under color of state law. Children have a constitutional right to live with their parents without government interference. Child's 4-month separation from his parents could be challenged under substantive due process. Sham procedures don't constitute true procedural due process. Although it is accurate that a trial court may consider prior parenting history, a finding of dependency must be based on proof of a parent's present inability to care for her children. Accordingly, the department had to prove Ms. W was presently unable to adequately care for her baby son. such that the child is in circumstances which constitute a danger of substantial damage to his psychological or physical development. When a judge knows that he/she lacks jurisdiction, or acts in the face of clearly valid statutes expressly depriving him/her of jurisdiction, judicial immunity is lost. Federal tort law, judges cannot invoke judicial immunity for acts that violate litigants' civil rights. A law repugnant of the Constitution is void, and that courts, as well as other departments, are bound by that instrument. Some defendants urge that any act of a judicial nature entitles the judge to absolute judicial immunity, but in a jurisdictional vacuum, that is absence of all jurisdictions, the second prong necessary to absolute judicial immunity is missing. Where there is no jurisdiction there can be no discretion, for discretion is incident to jurisdiction. The claim and exercise of a constitutional right cannot be converted into a crime. A denial of them would be a denial of due process of law. To survive a motion to dismiss, a complaint must contain sufficient factual matter, accepted as true, to state a claim for relief that is plausible on its face. Hence the act of filing a lawsuit against a government entity represents an exercise of the right to petition and thus invokes constitutional protection. 1983 Civil Rights Action Claim against the county under a Monell liability theory. 42 U.S.C. 1983 provides a mechanism for the private enforcement of substantive rights conferred by the Constitution and federal statutes. Section 1983 is not itself a source of substantive rights, but merely provides a method for vindicating federal rights elsewhere conferred. To state a claim under 1983, a plaintiff must allege the violation of a right secured by the Constitution and the laws of the United States, and must show that the alleged deprivation was committed by a person acting under color of law. Importantly, Monell does not provide a separate cause of action for the failure by the government to train its employees. It extends liability to a municipal organization where that organization's failure to train, or the policies or customs that it has sanctioned, led to an independent constitutional violation. Without a constitutional violation, no 1983 liability. Lies under a Monell theory or otherwise. The right to petition for redress of grievances is among the most precious of the liberties safeguarded in the Bill of Rights. Inseparable from the guaranteed rights entrenched in the First Amendment, the right to petition for redress of grievances occupies a preferred place in our system of representative government and enjoys a sanctity and a sanction not permitting dubious intrusions. It was not by accident or coincidence that the rights to freedom of speech and press were coupled with the rights of the people to peaceably assemble and petition for redress of grievances. A judge must be acting within his jurisdiction as to subject matter and person, to be entitled to immunity from civil action for his acts. If there is a state deprivation of a right secured by a federal statute, 1983 provides a remedial cause of action unless the state actor demonstrates by express provision or other specific evidence from the statute itself that Congress intended to foreclose such private enforcement. No judicial process, whatever form it may assume, can have any lawful authority outside of the limits of the jurisdiction of the court or judged by whom it is issued, and an attempt to enforce it beyond these boundaries is nothing less than lawless violence. It has been said that clear violations of the laws on reaching the result, such as acting without evidence when evidence is required, or making a decision contrary to the evidence, are just as much a jurisdictional error as is the failure to take proper steps to acquire jurisdiction at the beginning of the proceeding. The essential elements of due process of law are notice, an opportunity to be heard, and the right to defend in orderly proceeding. No man/woman in this country is so high that he/she is above the law. No officer of the law may set that law at defiance with impunity. All the officers of the government from the highest to the lowest are creatures of the law and are bound to obey it. Purpose of statute that mandates that any person who under the color of law subjected it another to deprivation of his constitutional rights, would be liable to the injured party in action at law was not to abolish communities available at common law, but to ensure the federal courts would have jurisdiction of constitutional claims against state officials. By law, a judge is a state officer. The judge then acts not as a judge but as a private person in his person. When a judge acts as a trespasser of the law, when a judge does not follow the law, the judge loses subject matter jurisdiction and the judge's orders are not voidable, but void, and of no legal force or effect. Acts in excess of judicial authority constitutes misconduct, particularly where a judge deliberately disregards the requirements of fairness and due process. The 11th Amendment was not intended to afford them freedom from liability in any case where, under the color of their office, they have injured one of the state's citizens. To grant them such immunity would be to create privileged class free from liability from wrongs inflicted or injuries threatened. Public agents must be liable to the law unless they are to be put above the law. Not every action by a judge is in the exercise of his/her judicial function. It is not a judicial function for a judge to commit an intentional tort. Occurs in the courthouse when a judge acts as a trespasser of the law. When a judge does not follow the law, the judge loses subject matter jurisdiction and the judge's orders are void of no legal force or effect. The purpose of the statute was to deter public officials from using their badge of their authority to violate persons' constitutional rights and to provide compensation and other relief to victims of constitutional deprivations when that deterrence failed. State law can create a right that the Due Process Clause will protect only if the state law contains 1. Substantive predicates governing official decision-making, and 2. Explicitly mandatory language specifying the outcome that must be reached if the substantive predicates have been met. Yes. Justice Byron R. White wrote the opinion for the 6-3 majority. The court held that municipalities may be liable for inadequate training of employees, but only when the failure to train amounts to deliberate indifference to the constitutional rights of the people with whom the employees will interact. A municipality is then only liable when the failure to train is a deliberate choice on the part of the city. The 14th Amendment's Due Process Clause protects parents' well-established liberty interest in the companionship, care, custody, and management of their children. Contrary to the district court's conclusion, we hold that any right that James may have was not clearly established on the basis of common sense. A right can be clearly established by common sense only where conduct is so patently violative of the constitutional right that reasonable officials would know without guidance from the courts that the action was unconstitutional. Where neglect is unfounded, however, removal of children from their homes for this time while caseworkers build their case is particularly disturbing. Undoubtedly it, 14th Amendment, forbids any arbitrary deprivation of life, liberty, or property, and secures equal protection to all under like circumstances in the enjoyment of their rights. It is enough that there is no discrimination in favor of one as against another of the same class, and due process of law within the meaning of the 5th and 14th Amendment is secured if the laws operate on all alike, and do not subject the individual to an arbitrary exercise of the powers of the government. Like its counterpart in the 5th Amendment, the Due Process Clause of the 14th Amendment was intended to prevent government from abusing its power, or employing it as an instrument of oppression. The Due Process Clause of the 14th Amendment does not require a state or local governmental entity to protect its citizens from private violence, or other mishaps not attributable to the conduct of its employees. ID, at 301. In so holding, the court specifically rejected the position endorsed by a divided panel of the Third Circuit. Once the state learns that a particular child is in danger of abuse from third parties and actually undertakes to protect him from that danger, a special relationship arises between it and the child which imposes an affirmative constitutional duty to provide adequate protection. Due process of law and equal protection of the laws are secured if the laws operate on all alike, and do not subject the individual to an arbitrary exercise of the powers of the government. Accordingly, a child is seized for purposes of the 4th and 14th Amendments when a representative of the state takes action causing a child to be detained at a hospital as part of a child abuse investigation, such that a reasonable person in the same position as the child's parent would believe that she cannot take her child home. Holding that a child was seized when a hospital told the child's parent that she could not take the child home. Social workers not entitled to qualified immunity for removing an infant from the hospital and placing her in a foster home without judicial authorization or a reason to believe that the child would be harmed while in the hospital. Whether the law placed a state actor on reasonable notice that her conduct would violate the Constitution must be determined in light of the specific context of the case, not as a broad general proposition. The 4th and 14th Amendments require that a consent not be coerced, by explicit or implicit means, by implied threat or covert force. The second prong of the qualified immunity analysis asks whether the right in question was clearly established at the time of the violation. Governmental actors are shielded from liability for civil damages if their actions did not violate clearly established statutory or constitutional rights of which a reasonable person would have known. The salient question is, whether the state of the law at the time of an incident provided fair warning to the defendants that their alleged conduct was unconstitutional. The 14th Amendment guarantees that parents will not be separated from their children without due process of law except in emergencies. Officials violate this right if they remove a child from the home absent information at the time of the seizure that establishes reasonable cause to believe that the child is in imminent danger of serious bodily injury and that the scope of the intrusion is reasonably necessary to avert that specific injury. The 4th Amendment also protects children from removal from their homes absent such a showing. Officials, including social workers, who remove a child from its home without a warrant must have reasonable cause to believe that the child is likely to experience serious bodily harm in the time that would be required to obtain a warrant. A seizure is a single act, and not a continuous fact. Absent conditions presenting an imminent risk of serious bodily harm, removing children from their home without obtaining judicial authorization is a violation of a parent's established 4th and 14th Amendment rights. In light of this extensive precedent, it cannot now be doubted that the Due Process Clause of the 14th Amendment protects the fundamental right of parents to make decisions concerning the care, custody, and control of their children. The innocent individual who is harmed by an abuse of governmental authority is assured that she will be compensated for her injury. A court must weigh, in the factual setting before it, whether the imminent risk to the child can be mitigated by reasonable efforts to avoid removal. It must balance that risk against the harm removal might bring, and it must determine factually which course is in the child's best interests. The innocent individual who is harmed by an abuse of governmental authority is assured that she will be compensated for her injury. The U.S. Supreme Court stated that when a state officer acts under a state law in a manner violative of the federal Constitution, he/she comes into conflict with the superior authority of that Constitution, and he is in that case stripped of her/his official or representative character and is subjected in her/his person to the consequences of her/his individual conduct. The state has no power to impart to her/him any immunity from the responsibility to the supreme authority of the United States. When a judicial officer acts entirely without jurisdiction, or without compliance with jurisdiction requisites, she may be held civilly liable for abuse of process even though her act involved a decision made in good faith that she had jurisdiction. However, a showing of probable cause does not satisfy the conclusion that MD was in imminent danger of serious physical injury sufficient to justify a warrantless removal. However, in her written claim, which was submitted on a form provided by the county, appears to contain several relevant allegations including names, dates, details, and causes of action based upon state grounds, violation of statutes, and intentional and negligent infliction of emotional distress. These details satisfy the threshold notice requirement of claim submission. While Maeve's CTCA submission contains duplicative claims addressed elsewhere in this opinion, at least 2 of these claims sound in state law, which are also presented in Maeve's opening brief on appeal: statutory violations and emotional distress. When the district court denies summary judgment on qualified immunity grounds, the appealable issue is a purely legal one: whether the facts alleged by the plaintiff support a claim of violation of clearly established law. To establish municipal, county, liability, the plaintiff must show that, 1. She was deprived of a constitutional right, 2. The county had a policy, 3. The policy amounted to a deliberate indifference to her constitutional right, and 4. The policy was the moving force behind the constitutional violation. It is well settled constitutional law that, absent exigent circumstances, probable cause alone cannot justify an officer's warrantless entry into a person's home. A material question of fact exists regarding whether there was reasonable cause to believe, on the basis of the information in the possession of the police officer, that the children faced an immediate threat of serious physical injury or death. Government officials are required to obtain prior judicial authorization before intruding on a parent's custody of her child unless they possess information at the time of the seizure that establishes reasonable cause to believe that the child is in imminent danger of serious bodily injury and that the scope of the intrusion is reasonably necessary to avert that specific injury. In the area of child abuse, as with the investigation and prosecution of all crimes, the state is constrained by the substantive and procedural guarantees of the Constitution. The fact that the suspected crime may be heinous whether it involves children or adults does not provide cause for the state to ignore the rights of the accused or any other parties. Parents and children may assert 14th Amendment claims if they are deprived of their liberty interest in the companionship and society of their child or parent through official conduct. Families in child abuse investigations are protected by two provisions of the Constitution, the Due Process Clause of the 14th Amendment and the Search and Seizure Clause of the 4th Amendment. Parents and children have a well-elaborated constitutional right to live together without governmental interference. That right is an essential liberty interest protected by the 14th Amendment's guarantee that parents and children will not be separated by the state without due process of law except in an emergency. Under the 14th Amendment right to familial association, an official who removes a child from parental custody without a warrant must have reasonable cause to believe that the child is likely to experience serious bodily harm in the time that would be required to obtain a warrant. Seizing and interrogating a suspected child abuse victim without parental consent violates the child's Fourth Amendment rights absent a warrant, court order, or exigent circumstances. The child subjected to seizure is also protected by the Fourth Amendment's prohibition against unreasonable searches and seizures. The 14th Amendment guarantees that parents will not be separated from their children without due process of law except in emergencies. Washington state statute does not authorize Children's Administration, CA, to accept referrals for CPS investigation or initiate court action on an unborn child. Guidelines for testing and reporting drug-exposed newborns in Washington state, July 2015, a person has been seized within the meaning of the Fourth Amendment, if, in view of all of the circumstances surrounding the incident, a reasonable person would have believed that he was not free to leave. Under the Fourth Amendment, we must determine whether the defendant's alleged conduct constituted a seizure and if so, whether the seizure was unreasonable in light of the factual allegations. Qualified immunity shields a government official from liability for civil damages if, 1. the law governing the official's conduct was clearly established, and, 2. under that law, the official objectively could have believed that her conduct was lawful. Noting that a warrant, probable cause, or a reasonable belief that a child is in imminent harm is necessary to justify a seizure of a child under the Fourth Amendment, the state may not remove children from their parents' custody without a court order unless there is specific, articulable evidence that provides reasonable cause to believe that a child is in imminent danger of abuse. The police cannot seize children suspected of being abused or neglected unless reasonable avenues of investigation are first pursued, particularly where it is not clear that a crime has been or will be committed. ID. Whether a reasonable avenue of investigation exists, however, depends in part upon the time element and nature of the allegations. To establish personal liability in a 1983 action, the plaintiff must show that the government officer caused the deprivation of a federal right. An official causes a constitutional violation if he sets in motion a series of events that defendant knew or reasonably should have known would cause others to deprive plaintiff of constitutional rights. An official satisfies the personal responsibility required of 1983 if she acts or fails to act with a deliberate or reckless disregard of plaintiff's constitutional rights, or if the conduct causing the constitutional deprivation occurs at her direction or with her knowledge or consent. A custom or policy may be established by an allegation that the constitutional injury was caused by a person with final policy-making authority. While a private citizen cannot ordinarily be held liable under Section 1983 because that statute requires action under color of state law, if a private citizen conspires with a state actor, then the private citizen is subject to Section 1983 liability. To establish Section 1983 liability through a conspiracy theory, a plaintiff must demonstrate that, 1. A state official and private individual, s. reached an understanding to deprive the plaintiff of his constitutional rights, and, 2. Those individual, s. were willful participants in joint activity with the state or its agents. If the defendants conceal exculpatory evidence and plaintiff is further deprived of possession of her child, this is a violation of her fair trial rights under the 14th Amendment Due Process Clause and is actionable under Section 1983. Finally, we note that to the extent the defendants knew the allegations of child neglect were false, or withheld material information, and nonetheless caused, or conspired to cause, C.A.'s removal from his home, they violated the Fourth Amendment. Government officials' procurement of a court order to remove children based on information they knew was founded on distortion, misrepresentation, and omission, violated the Fourth Amendment. Prior to the events in question, we had repeatedly held that a family's rights were violated if the children were removed absent an imminent risk of serious bodily harm. A reasonable social worker would need nothing more to understand that she may not remove a child from his or her home on the basis of a situation that does not present such a risk. When determining whether a parent can discharge parental responsibilities, the court must consider how the substance abuse hinders the parent's ability to effectively parent. In making this finding, the court has flexibility to consider the circumstances of each case. A two-step sequence for resolving government officials' qualified immunity claims: a court must decide, 1. whether the facts alleged or shown by the plaintiff make out a violation of a constitutional right, and, 2. if so, whether that right was clearly established at the time of the defendant's alleged misconduct. Qualified immunity applies unless the official's conduct violated such a right. Balances, on the one hand, the need to protect children from abuse and neglect and, on the other, the preservation of the essential privacy and liberty interests that families are guaranteed under both the 4th and 14th Amendments of our Constitution. Our conclusion that no exigency existed here is also supported by the fact that the Child Protective Services delayed in investigating the case and in removing the children. Holding that a 14-day delay by social workers in entering the family home to investigate a report of abuse is evidence of lack of exigency. When officials have reasonable cause to believe that the child is likely to experience serious bodily harm in the time that would be required to obtain a warrant. However, it is not necessary that a case be on all fours with the facts of the instant case. A right is clearly established if the contours of the right are sufficiently clear that a reasonable official would understand that what he is doing violates that right. The doctrine of qualified immunity protects government officials from liability for civil damages insofar as their conduct does not violate clearly established statutory or constitutional rights of which a reasonable person would have known. Families have a well-elaborated constitutional right to live together without governmental interference. However, an official's prior willingness to leave the children in their home militates against a finding of exigency, as does information that the abuse occurs only on certain dates or at certain times of day. The claims of the parents in this regard should properly be assessed under the 14th Amendment standard for interference with the right to family association. But because only the children are subjected to a seizure, their claims should properly be assessed under the 4th Amendment. Parents cannot assert that the seizure of their child violated their own 4th Amendment rights. The district court did not appear to disagree with the premise that a parent is authorized to assert causes of action belonging to his minor child on behalf of the child. A minor or an incompetent person who does not have a duly appointed representative may sue by a next friend or by a guardian ad litem. For child removal claims brought by the child, we have concluded that the Constitution provides an alternative, more specific source of protection than substantive due process. When a child is taken into state custody, his or her person is seized for 4th Amendment purposes. The child may therefore assert a claim under the Fourth Amendment that the seizure of his or her person was unreasonable.